there are a number of procedures that exist at international level to provide remedies in instances of human rights violations. Within the Council of Europe, the most visible are the European Court of Human Rights under the European Convention on Human Rights and the European Committee of Social Rights under the European Social Charter, initially adopted in 1961 and revised in 1996. We have a number of procedures established under the United Nations human rights treaties. We have 9 human rights treaties, each of which established one committee of experts, one human rights treaty body, as they are called, composed of independent experts who receive states' reports and can receive individual communications filed against states who are denounced for not complying with their international obligations. Mostly these expert bodies, committees, courts require that the case be presented first before the domestic jurisdictions, and that the local remedies available within the domestic legal order be exhausted before the claim can be filed at international level. And that, of course, requires the victim to go through appeals proceedings, cassation proceedings at domestic level before the issue can be raised internationally. There are exceptions to this rule, and particularly within the European Committee of Social Rights, which has a unique procedure called a procedure of collective complaints, allowing trade unions, allowing non-governmental organizations that are listed on the list established within the Council of Europe to file complaints against a state, even without having to go through the local remedies available within the domestic legal order. But that is quite exceptional. Now, this proliferation of procedures and this coexistence of different human rights bodies, judicial or quasi-judicial bodies, is also a source of complexity and may make it difficult for lawyers to choose between all these procedures which is the most appropriate one to use in any particular instance.